The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. Attorney Tommy Siniard is joining us tonight, and he is also joined by criminal defense attorney Andy Segal. Good evening, gentlemen.
Hey, Aaron. How are you?
Doing great. So glad to have your expertise here this evening. And we're talking about kind of the differences between civil and criminal, and somehow they intersect as well.
Yeah, so, we do nothing but civil law. Andy does mostly.
No, just completely
Criminal law. The difference is, in a criminal setting, a person is generally arrested and goes through a different set of circumstances in the courts than does a civil case. You have a criminal defendant, it's prosecuted not by plaintiff's lawyers like myself, but by paid district attorneys. And they're obligated to prosecute the case. And the rules are different in terms of the burden of proof. It's higher in a criminal case. It's beyond, to convict a criminal, you have to prove beyond a reasonable doubt to a moral certainty. It's less of a burden in a civil case, the theory being you don't want to take away anybody's liberty unnecessarily. In the civil setting, we only have to prove things by a preponderance of the evidence. And so those are the biggest differences. Andy navigates the criminal system very well, by introduction. Andy practices law with his son, who's a genius, John Paul. Andy graduated 40 years ago, so our careers shadow each other. And here's the things that baffle people. This guy who now defends criminals used to prosecute them both at the state level and at the county level. He's been on the Attorney General's staff and on the DA's staff. And to top it off, he was a municipal judge for 20 years. And people go, how do you...
Probably makes him a better attorney to be able to do both sides.
How do you square that? But we find that many former prosecutors become defense lawyers, right?
It's pretty common because we're switching tables. You're very used to dealing with the burden of proof. Tommy was talking about, civil versus criminal. For defense lawyers, what we're looking at is, can the state rule out a reasonable doubt? They always show the scales of justice, which I always feel is a little bit wrong, because it's not a weighing in a criminal case. It's, is there doesn't have to be, if they have 5 things saying that the guy is guilty, but we have one reasonable point saying he's not, and you can't rule that out as a possibility, then under our law, the person is entitled to be found now not guilty. But as Tommy said, being found not guilty is not the same thing as saying that a person is innocent of having committed whatever acts. It's saying that the state has not met the legal burden. And that's why, there's plenty of cases where a fellow may be found not guilty, but still be held accountable on the civil side, as Tommy's explained very well.
So you all actually overlap sometimes and work together, which is really interesting.
Well, yeah, we were talking before the show. We do personal injury, and that is just not car wrecks. A lot of these firms that advertise on TV and have all the billboards just take car wrecks. They rarely file them, litigate them. They take the low-hanging fruit. They deal in volume. We handle not only car wrecks and truck wrecks, but workers' comp, which they don't, products liability, which they don't, nursing home abuse and neglect, which they don't, and other areas of personal injury law. And we actually file cases, litigate them, and finish them. And we don't get paid until we win. And it's on a percentage. The intersection between our two careers is that, unlikely as it may seem, crime victims sometimes have a civil case against the perpetrator. So there's this wild intersection that people don't realize, and we take these cases and we've been very successful with them. So we urge anybody that has a question in that area to call us. Andy, what I really value about Andy is not just his legal skill, but he is a voice for those who have multitudes of questions. I don't know how many questions he fields a day. I mean, he's on YouTube. He puts himself on platforms and puts himself out there to answer all shapes and kinds of legal questions. So I'd encourage you to use his services, which are largely no charge, unless he takes the case. But he is a useful tool in our North Alabama segment of lawyers.
Awesome. So if you have questions on this topic or any other legal topic, you can just email us at questions@siniardlaw.com or call us at 844-7000-LAW, and your question may be featured. And now back to Tommy and Andy. There is a new death penalty law for child sex offenders. So tell us about this. It may not even be legal?
The Supreme Court says it's not legal. Alabama, so first off, let's talk about what it is. Alabama has passed a law saying that for certain sexual offenses, the death penalty is on the table. In the past, the death penalty only applied to some form of murder cases. And that's still the law according to the Supreme Court. Alabama, and I'm not talking about the ethics of it, but Alabama has passed a law saying, hey, you can give the death penalty in certain egregious child sexual cases. You know, a young child is raped, and of course, nobody's rooting for people to do these kind of things. The question is, well, the first question is, can they do it? And one of the issues, and I've addressed this previously, is the state of Alabama now is going to spend an enormous amount of money to litigate an issue with the hope that they can get the Supreme Court of the United States to change its mind. They may be successful. The Supreme
like an
Court,
uphill battle.
It is an uphill battle.
Yeah.
The Supreme Court at the time that passed the law saying, no, death penalty is reserved for the most serious of cases and those involving a death. However, the composition of the Supreme Court has changed. We have different justices. And so my best guess is that the state of Alabama is hoping that maybe the Supreme Court will revisit it. Depending on your politics, I'll let an individual person decide, is it worth it? I think that we're spending a bunch of money that could be spent on other things, since I do think it's an uphill battle, and the state of Alabama is going against precedent of the United States Supreme Court. I mean, any lawyer who has a client who is sentenced to death for a non-murder related case, well, of course they're going to appeal it, and if a judge imposes it, because you've got to convince a judge to disregard existing law of the highest court in the land.
Yep.
All right, when we return, we'll have a special guest, Teresa Wilson. She is the CEO of Rose of Sharon Soup Kitchen.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
Tonight, in our community spotlight, the Rose of Sharon Soup Kitchen. It goes way beyond a warm bowl of soup.
Thank you, Aaron. Very fortunate to be here with a local hero, in my view, Teresa Wilson. She's the CEO of the Rose of Sharon, which is a homeless soup kitchen which serves really all of North Alabama. Mm-hmm. Teresa was a ICU nurse for 15 years. And then in El Paso, Texas, and then got the call from God to do homeless ministry, and has been at the Rose of Sharon since 2017. And today we're going to explain how that works, and we really welcome you to the Siniard Law Show. Thank you.
Thank you for having me.
Tell us a little bit about what the Rose of Sharon is and what it does.
Yeah, the Rose of Sharon Soup Kitchen has been in North Huntsville since 2003, so over 20 years, and been providing meals. When I took over, they were serving maybe 40 people a day. I serve over 300 meals a day now. So we've grown over the years, and just growing our resources that we offer the community, not just food, but we offer a computer lab to help people get jobs and get employment and to further their lives. And we're there every step of the way. And when I took over, it was dining with dignity. That's what God told me. So I put tablecloths on the tables and fresh flowers, and nobody goes through a line. It's like a diner.
Really?
And it promotes dignity, and it promotes that family feel there. And we don't just serve the homeless in Huntsville, we serve everyone.
All comers.
All comers. There's no criteria for our services.
Like when you were telling me when there was a government shutdown and people were furloughed, these would be some high-end income earners
Right.
that are showing up
Yes.
hungry.
Hungry and with families. And we did have some furloughed people actually come in and need our assistance with food, but they also wanted to give back, so they volunteered their time while they were furloughed at our soup kitchen. And that just goes to show you, our community especially is very generous, and people are very grateful to have us here and use our resources, but they're also willing to give back.
So you were telling me before the show that it takes nearly $30,000 a month to run the Rose of Sharon. Where do you harvest those resources?
Private donations, and we do write for corporate grants here in town. We rely heavily on just private donations and people getting the word out. And God provides every month. The summer months are the hardest, and we're feeling it now at the Rose of Sharon as our funds are diminishing. But we just keep going, and we trust in God that He will provide.
Living on faith.
Living on faith.
So how many people do you service a month through the Rose of Sharon? Have you got a good estimate?
I would say probably around 3,000 different people.
Wow.
And it's families, and it's kids, and it's people that come in and want to give back. Like, we have local farm owners and stuff. They bring us eggs, which is so needed because we'll use 45 dozen a day.
Wow.
To feed breakfast there. So we just rely on local people to give back. And then we want to provide a service to anyone, no criteria. If you need help, I'm very transparent. I'm very attainable. You can come and see me anytime you want. I'm not hidden in an office somewhere. I'm usually right smack in the dab in the middle of the dining room doing my thing because I love people and I want to be there for them and help them through the hard times.
Do you find that many of the people are repeats?
Some, but we see new people there every day.
Really?
Yeah, every day.
I know this might not be appropriate, but do you ever feel in danger? I know some of these people have substance abuse problems and mental illness.
They do. We deal with a lot of people that have those issues, mental illness, substance abuse. I've been doing it so long, they call me Mama T. Most of the homeless are those kind of people. They call me Mama T, and we have a great relationship. I think I'm more protected there than I am anywhere in Huntsville.
You're safer there than out on the street.
Yeah, because they know me as Mama.
Yeah.
And I love them, and they love me.
Right. So if someone wanted to contribute either their time or their money, how would they go about doing that, Teresa?
We have a website, rosesharonsoupkitchen.org. We have a donate button there. We take checks. They can come in with monetary donations anytime. We also need people that come in and take a tour and see exactly what we do, because once you're in there, you can't forget it. Come and volunteer. Come and bring in coffee and creamer, which is something that we use so heavily every day. And we need the public to help and bring in that food.
Do you have any formal way of soliciting contributions other through something
like this? We do
fundraisers.
We do fundraising we do like mail out a newsletter and requests for funds. We we do like Chick-fil-A nights and things like that. Chick-fil-A has been so great to us, but we do different things like that. We just don't have the funds to do the big galas and things like that have a lot of overhead. So it makes it a little tricky, but we just trust.
It's like a street level charity.
It's very grassroots, but it does huge things.
What is your biggest blessing from going into this ministry for the homeless and the hungry? What drives you?
What drives me? My relationship with Jesus drives me every day, of course. His mercies are new every morning. But I had the opportunity to live ministry for the past 20 years. And the people that I met and the people's lives that have been changed because they came to the Rose of Sharon or I helped them in some way. It's countless people. My heart is overflowing with joy because of that. It's not easy work at all. It's very emotional. I'm very vested. They tell you in nursing and other places, don't get emotionally involved with your patients. And I always took that as, nah, I'm not going to do that. That's not me. That's not my heart. So I'm very emotionally involved with people. I've walked with drug addicts for 5-6 years now, the same ones, in and out of rehabs, jail and things like that. And
So he's a special person.
And
you gave up a career as an ICU nurse, highly paid, big pay cut to do charity, right?
Well, yeah, but when God calls, you answer. And with that obedience, there's always a blessing. And I can't tell you just how wonderful my life has been because being in that place and being at the Rose of Sharon.
God bless you, Teresa. If anybody would like to contribute to the Rose of Sharon, it's a great charity. Our firm will match any contribution up to $5,000.
Wow.
And I urge you to get off your billfold.
Thank you.
Thank you for being here.
Thank you.
When the Siniard Law Show returns, we'll get more of your legal questions and we'll tell you how you can sign up for the Siniard Law Firm's free monthly newsletter.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, just scan the QR code or be sure to sign up at siniardlaw.com. Tommy Siniard and criminal attorney Andy Segal are with us this evening. So let's get to one of our viewer questions. This is a voicemail from Betty.
This is Betty, and I have a nephew that was, a niece that was physically beaten and left on the side of the road, and she's been subpoenaed by the court. But she's too afraid to go to court, and they said if she does not go to court, she will get a warrant put out for her arrest, but she's too afraid to go. Can she not go to court and not get a subpoena and not get a warrant put out for her if she does not go?
She should go to court. First off, let me explain what a subpoena is. A subpoena comes from sub, like submarine, or under, and poena means penalty, under penalty. And when the person gets a subpoena, it means you are to abide by this order under penalty of law. If somebody disregards it, the judge can, and I've seen it happen. Judge says, okay, we're going to have a pickup order, and that person, although they're not the person charged, they can get picked up, have law enforcement pick them up, and they can sit in that jail until the court date.
The interesting verb there is have the person attached.
Right. Yeah. I mean, heck, when I was a prosecutor, I'd do it. I'd say, Judge, I want an attachment order. And cop would go out and they
Could be at
snatch
work,
that person.
right?
But wherever
Could be at
they can
church.
find them.
Oh my goodness.
So, don't skip court.
Yeah. All right, good. Bottom line. So we have an email question, Andy, from Jessica. She says, My son was arrested with a lot of marijuana in his car. Someone with the police department told me that they had to measure the amount of marijuana before deciding charges. So what are the potential charges and penalties?
Okay, so it really, I don't know what a lot is, but in Alabama, simple possession of marijuana, a small amount, of course, is a misdemeanor. If they think that you are in possession of marijuana for other than your own personal use, or you have a prior marijuana conviction, it's elevated to marijuana first. If they think that you are selling it, assuming that they have sufficient evidence, then you can be charged with distribution. And of course, the bell ringer, the big serious one, is if the marijuana weighs over 2.2 pounds a kilo, then they're charged with trafficking. And trafficking is the big dog in criminal drug cases.
What's the penalty for trafficking?
Penalty for trafficking, it does depend on the weight. The minimum penalty for trafficking is 10 years in prison and serve 3 years. It can go all the way up to life. If there's a larger quantity, and for all drug cases it works this way, trafficking basically means people get this image of speedboats in Miami Vice. That's not what it is. It's that a person is shown to have been in knowing possession of the drugs, and the drugs exceed what the law says is the amount for trafficking. So if this young man has over 2.2 pounds, he's going to be looking at a trafficking charge on up, and the range varies depending on, if he has 100 pounds or more, it goes up after certain amounts of weight.
What about his age? She said that he's 18 years old.
Yeah, where does youthful offender apply?
Right, well, so Alabama has decided, I think wisely, that sometimes we all do stupid stuff, but Alabama has made it a law that if a young person, somebody under the age of 21 at the time of the offense, has done something dumb and a judge wants to cut the person a break, they can do so through something called the Youthful Offender Act. And what the Youthful Offender Act does, it does a couple of things, but it says that if the judge grants youthful offender status, that person's criminal record, or what would be that person's criminal record, it is sealed. It's not publicly available. It's not even considered a conviction for a crime. Now, people get confused because you're still subject to punishment. However, the range of punishment is reduced to no more, no more than 3 years. So a guy if a judge chose to do it on a trafficking case, well, if the fellow was found to have committed that act, he'd still be potentially sentenced up to 3 years, but it's not going to be 10. It's not going to be life. So it's a big advantage for people who are granted youthful offender.
So the defense lawyer, and stop me if I'm wrong, has to file or make application for youthful offender status.
Absolutely.
And then there is a judicial determination by the court as to whether or not, and the judge in his discretion, he's not obligated to give this special status. So this goes, all youthful offender cases are non-jury, correct?
Yes.
And the maximum punishment, or the punishment range, is 0 to 3 years. Many times, even if the defendant is found guilty, they're given some sort of split sentence or probation because of their age. And so if you've got a defense lawyer and you have a defendant under the age of 21, it's legal malpractice not to apply for youthful offender status. Seasoned guys like Andy would never miss that, but you'd be surprised at some people that do a lot of new lawyers that do court-appointed work who've never heard of it, right?
Well, and I hope I never miss it, but it is also the obligation of the court to inquire and try to, and I have had times where, I'll find out, well, gee, did they ask? And the remedy that I would do is I would ask a judge for retroactive application of it.
Oh, okay.
And try to fix it, because it does give a huge benefit for somebody. If you're branded as a felon and you're trying to find a job, your life is much more difficult. And so there's other things in Alabama law like expungement, but it really does help a young person who's, hey, they were a kid and they did something dumb.
The other additional benefit of youthful offender status is that your record is sealed. So even if an employer makes an inquiry, have you ever been convicted or even arrested, you can lawfully say no. So, that keeps a black mark for employment purposes or whatever away. So it's a hugely important opportunity.
All right, let's get to one last email question. This email comes from Hunter. He says, I got into a fight outside a bar. The other person ended up going to the hospital. The cops were called and I was arrested for assault. I believe I was defending myself. I've been appointed a lawyer by the court, but I'm still not sure what I'm facing. Any guidance is appreciated.
Sure. Well, it depends on, in an assault case, we're talking about two different things. What is he charged with? He's charged with some form of assault, and depending on how serious the injuries are, whether or not a weapon was used, those factors determine what level of assault. Of course, the lowest, if somebody punches me in the face and whatever, I get a black eye, that's a misdemeanor assault. If somebody is wearing brass knuckles and punches me in the face and I get a black eye because there's a weapon involved, then it's a felony. If I have a serious injury, I lose my eye, yes, it's a felony, but a more serious felony. So all of these factors come into play. Now, as to the issue of self-defense, under the law, self-defense is something that is considered an affirmative defense. In criminal cases, almost always, as we've talked about, the state has the burden of proving things, of going forward. However, in an affirmative defense, it means that the person who's accused, they need to put forth some evidence. So Alabama self-defense law has changed in recent years, and there's a couple of issues. One, in some instances, a person will have a hearing, basically an immunity hearing, if they choose to. They don't have to, in front of a judge. And if the judge, and I had one of these where a guy chased another guy, he was yelling racial slurs, he was doing all sorts of inappropriate things, chased him into a parking lot. My guy pulled over, the other guy pulls over, gets out, smashes the guy's rear view mirror, not side mirror, and then comes around and he pulls up his shirt and he puts his hand down his pants as if to reach for a gun. My guy shot him right through the hand into the waist. Well, the issue is, was he acting reasonable under the circumstances? Different people may say different things. Fortunately, the case went away. So in those kind of situations, you can have a pretrial hearing where a judge, and if the judge rules, and this would affect Tommy's stuff too, if the judge rules that the person acted correctly, acted in self-defense, then they have immunity from prosecution and, I believe, from civil suit. So the case is, it's done, that person's safe. Now, the judge can rule against them. That doesn't mean they can't raise that issue at trial, but they're no longer granted the immunity of it,
right.
And they do have the burden of showing that.
All right, very good. So informative. We appreciated Andy and Tommy for all of this information about criminal law, and we look forward to hearing from you, our viewers, with your questions about any legal topic. You can email us at questions@siniardlaw.com or call our voicemail line at 844-7000-LAW. Join us next Sunday night after the late news. Good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.